Good morning and welcome to today's Ask a Pro series. This is, I think, the 15th edition of these Ask a Pros that the firm has provided. Today's topic is called Secrets of the Subrogation Attorney. My name is Ted Traut, and I will be the moderator for today's session. I'm the Subrogation Group Chair, and I'm a shareholder here at the firm. I work out of the firm's Cleveland office. In my role, I handle subrogation claims in the state of Ohio, and I also act as sort of in-house counsel for our collections and forwarding network, as well as manage many of the client relationships with our subrogation clients. I also handle some creditors' rights matters just to keep a foothold in that area. I have been an attorney for 23 years, and I have handled subrogation matters this entire time. Personally, I live in the Northeast Ohio area with my wife and son, and I'm a huge sports fan. Go Cavs. I love to play golf, even though I'm pretty much a hacker. And my latest thing is that I started doing Taekwondo about a year ago with my son, so I get beat up a couple times a week doing that, which is all fun and all well and good. So before I introduce you to the rest of our panelists, I do want to add, for those who may not know, so we are a national subrogation law firm. We handle collection matters on a national basis, and we also provide litigation services. For the litigation services, we handle with Weltman attorneys matters in Ohio, Kentucky, Indiana, Illinois, Michigan, Pennsylvania, and New Jersey. So those 7 states are what we refer to as our footprint states. Those are matters that are handled by Weltman attorneys. And then we have a national network of attorneys that handle matters in most of the rest of the country. So with that aside, I'm going to go and let you learn a little bit more about the other panelists. Let's start off with Mike Chapman.
Hello, everybody. I've been a lawyer for 22 years. I was briefly a high school math and science teacher before going to law school at Indiana University. Go Big Ten sports. I've primarily been doing defense work, handling insurance defense, transportation, premises, and product liability claims. But I've always maintained a few subrogation cases, and now that I'm doing subrogation full-time, I'm super excited, and I'm admitted in Ohio, Indiana, and Kentucky.
All right, let's hear a little bit about Cameron Deane.
Thank you, Ted. Good morning, everyone. So I'm an attorney in our Philadelphia office, primarily handling subrogation matters both in the states of Pennsylvania and New Jersey. I've been doing litigation work since I began practicing, and that has ranged from criminal defense early on to property damage claims to other bankruptcy litigation. And since joining Weltman just over a year ago, it's been primarily subrogation that I've been handling. In addition to subrogation practice here, I also handle some consumer collections and bankruptcy matters for the firm. Outside of the office, I am a resident of Philadelphia, big fan of our sports teams here as well. And I like to mostly spend my free time outdoors, whether it's camping or golfing or hitting the ski slopes in the wintertime.
Let's hear from Tiffani.
Hello, everyone. I'm so glad everybody was able to attend. My name is Tiffani Williams. I'm a subrogation attorney in the state of Michigan. I will start off that I am not a sports fan whatsoever. However, I've been practicing for approximately 12 years. Prior to practicing, I actually worked at an insurance company as a claims adjuster. Liked it so much, went to law school, and then here I am. I basically manage the Michigan portfolio and assist Ted in managing the subrogation portfolio throughout the firm. As far as my personal life, I already mentioned I do not like sports, but I do have 2 little children. I have a 4-year-old and a 5-year-old son, and I'm getting married this year in September.
Congratulations on that. So before we get started, we got a few moments, take a moment to get through a few housekeeping items. So we want this to be an interactive session as much as possible. In fact, I believe all the questions were drafted by registrants. So, if you don't like them, it's not on us, that's on you. So, but seriously, if you have any questions throughout the session that you want to type into the chat box, we'll try to get to those. And if we can't get to those, we'll reach out to you offline and we can give you a response. So really the whole idea is it's an Ask a Pro. We've got these professionals here, and any questions that might pop in your head that are germane to your practice area or your claims, well, feel free. We'll put those in the chat box. We'll try to get to them. This webinar is being recorded. At the end of the session, there will be a link to the recording, and a copy will be the presentation slides will be sent to you all. Also, there's going to be a short survey on the screen at the conclusion of the event. Please take the short survey and share your feedback. We greatly appreciate your opinions on our webinars. It helps us to form the content for future webinars and let us know what you need or what you desire. Lastly, we do have a legal notice because we are lawyers, so we've got to lawyer this up a little bit. And I was going to wrap this, but I didn't have time to get my flow going. So I'll just read it for you, try not to make it too painful, but this is basically our cover ourselves. We're not dispensing legal advice. So this seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided are not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. The presenters advise you to seek competent legal advice on these topics. This seminar or seminar material does not create any attorney-client relationship between you and the law firm of Waltman, Weinberg, and Reese. So aren't you glad you didn't have to hear me rap? So with that being said, we'll get on to the questions and get on to the content part of the program. The first question that one of our registrants posed was, what are the key things you should have in your subrogation file to increase recovery potential? Let's see. Let's have Tiffany start off with that one.
Okay, Ted. So some of the key things you want to have in your subrogation claims file will be your liability determination. So if you have documentation regarding who's at fault, any information that you gathered, whether it's witness statements, police reports, anything to help you determine who's at fault. In addition, you want to have your proof of damages. So whether that's vehicle evaluations, appraisal reports, expert reports that attest to actually the damages that are contained or that you're attempting to recover. Anything that's going to support those damages, estimates, photographs, whether it's the actual damage to the vehicle or property, or actual scene, the scene of the accident or where the loss occurred. And then also you want to have your chain of custody if you have external evidence. So if you're using an expert report, make sure you have documented the chain of custody regarding any documents items you have preserved in the course of adjusting the claim. So you want to make sure you have those key things, your liability determination, your proof of damages, and have those all encased in your claim file. And as just a little reminder, that's also what you want to provide to your subrogation professional as well. All those things are needed in order to assess whether a claim is viable, and also they're needed in the course of litigation. So those are the documents and information you should have in the claims file.
Do you recommend that the carrier submit their entire claims file to you?
Well, I always like the claims file, the entire claims file, and any of my clients that are on here that I work directly with, they will know I love everything in the beginning up front. But the key things that we need would be the proof of damages, your liability statements, and then your claim notes, because sometimes, insurance company may identify a claim and they believe that that's a viable claim, but there may be actual other claims that exist, but we need the additional information to assess that. So you may refer it over as maybe an uninsured file, but you have some other collection potential, maybe against another insurance company or some other tortfeasor altogether. So it's better to provide us with more information so we can assess all the potential claims you may have, but at the very least, we need the proof of damages, your liability determination, and your claim notes.
Do any other panelists have something to add to that?
This is Mike Chapman. I also like to look for contact information. It really helps us if the claims handler can secure contact information for various parties, witnesses, police, fire, EMS. I also like to see a demand letter and maybe a preservation letter issued to the potentially at-fault parties. If you're trying to increase or maximize recovery, in my opinion, acting quickly and sort of putting everybody on notice can make a huge difference, because you never know when somebody's going to say you need to look a different direction, or somebody says, hey, we'll pay the claim.
No, this is Cameron Deane. I agree a lot with what Mike just said, especially regarding the contact information. That is something that can, at the end of the day, when it's the day of trial, that can be the thing that makes or breaks your case. Is you've prepared all this information, you have a litigation strategy, and then suddenly your insured is not present to testify. And if your contact information's out of date or something along those lines, you're going to have a very tough case, if any case at all, to present. But I also wanted to follow up on what Tiffani said. She mentioned all the things that I agree are key to having a claim be presented. But I also agree that the more information we can get our hands on, the better, whether that's to determine if there's any additional tortfeasors or just to evaluate the claim in a more thorough process to see, what other potential damages are there to recover upon. So.
And I'm going to offer a friendly addendum to all of this, because I think you're all spot on and exactly right, particularly with the litigation claim. However, I've done this long enough and worked with enough clients that I don't want to lose out on the collection aspect of it. So I do often get approached by clients who want to place a high volume of collection matters that they're not sure whether they want to actually litigate, and they want to know what's the bare minimum, because they're looking at resources on their end, and what's the bare minimum you need to at least get a collection letter out. And so I would say for that, to answer that question, which is a slightly different question, would be, you at least need the amount of damages and the loss amount secured and how that was paid out, and the at-fault party, and even to have a talk-off for a collector. I think it's important to at least have a police report or an incident report or some explanation or narrative on how the loss occurred, to have a meaningful talk-off. So I do think there are times when clients can get you a bare minimum amount of information, but I think the moment you're going to, I'm sure there's pros and cons to each approach, but the moment you are going to litigate, I think the more information, the better. So to sum up. So let's move on to the next question. Okay, so the question was talking about preservation of evidence, and I think with Mike's background, particularly in doing cross liability work and things of that nature, I'd like to hear from Mike first and hear what he has to say.
Sure. Well, in the property and casualty context, the first thing I recommend is that you make sure you keep the product. So whether it's a component part or a construction defect or an appliance, you want to make sure that you somehow preserve the product. I like to document ownership, maintenance, and control. Those always become issues in any product claim. Try to grab the paper. There's usually invoices, purchase receipts, product manuals, maintenance records. There are things to obtain. Then there's usually an accident. So I do like to see preservation of the incident reports or correspondence that might discuss who was there and how the incident happened. Of course, it's always important to take plenty of photographs, take video if you can. Try to get recorded statements, because what happens is memories are fleeting, and sometimes these things don't come out until 2 or 3 years later. If there's any doubt, I always recommend getting help from a cause and origin expert, depending on the nature of the loss, or an attorney, because invariably, when you're getting into litigation, there's always some little nugget of information that we wish we would have had 3 years ago. So the earlier you can contact an expert, the better. It's super important to preserve the chain of custody. When you're preserving the product or the appliance or the paper or the video or the picture, you want to make sure that you know who's put hands on those items. And then last, it's super important to put everybody on notice early. You want to make sure that you get a preservation letter and a notice letter out to everybody. And I'm talking about sellers, retailers, maintenance providers, manufacturers, because what we see in today's society is, you might send it to big manufacturer LLC, but they didn't actually make the product. Somebody else made the product for them. So the sooner you can get those letters out, the more information you'll get in return, and then you'll be on the right track to pursuing the at-fault party.
And if I could, Ted, I just want to jump in.
Looked like you wanted to say something. Yeah.
Michael is exactly.
That's a lot of stuff.
Yes, Michael is exactly correct. And I want to more talk about what is evidence. And so the lost vehicle is evidence. And so that's probably the biggest area where I see subrogation professionals maybe miss opportunity. What will happen is the claim will be adjusted, the underlying claim will be adjusted. You know, you'll have your property damage person go out, write the estimate, either get it repaired right away or it's a total loss and it goes over to salvage, and never identify the potential tortfeasor or at-fault person when there is a situation where maybe there was a mechanical failure and you're going after, you know, a manufacturer of something, or there was an issue with putting tires on the vehicle and that was why the loss occurred. So when you're not going against the other person in the accident, the typical tortfeasor, but you're going after a manufacturer of some part or some kind of faulty service that was done to the insured vehicle, whatever that vehicle may be, you want to make sure you preserve that as well. So if you can preserve it, that's best, but usually you can't because you have obligations to meet for the actual insured. So you want to put the other party on notice. Make sure they have an opportunity to come out and inspect it right away and, you know, take whatever pictures they need to take or have their expert take a look at, because once the vehicle is sold for salvage, we're never going to find it again. And then once it's repaired, you know, they potentially have a claim for spoliation and they're not able to assess whether that damage is really related to the motor vehicle accident or whatever, you know, whatever the cause of action was. So just remember that the vehicle is also evidence as well.
Good point. Just want to underline that. So you're talking about situations where we're pursuing a manufacturer for a defect or some sort of negligent repair or maintenance claim. Then the vehicle is, but in your run-of-the-mill fender bender, that's not somewhere, you know, you understand that the clients have to repair the vehicle, but you're talking about a sort of out of the ordinary claim. Correct?
Correct. So not when the loss is a result of the at-fault actions of the other motorists, but when the loss is a result of some negligence on some other entity that wasn't involved in the accident. So just as you enumerated, you know, the manufacturer, again, the service repair, any type of work that was done on the vehicle. That's what I'm referring to. And the vehicle is always evidence in any situation, but as far as the key time to preserve it is when you have a situation where potentially if it's spoiled, as far as, you know, getting repaired or it's deemed a total loss and the vehicle is lost as a result of salvage, we can't really get back that evidence anymore. So again, not in the context of a normal run-of-the-mill motor vehicle accident when the cause is from the tortfeasor.
Okay. Cam, I think that covered it. You got
No,
anything else?
Well, just briefly, I know Tiffani kind of mentioned the magic word spoliation, which is always something that can scare me if an opposing attorney is bringing that up. And, you know, I think it's worth mentioning that issue can apply to all evidence really that gets created through the claims investigation process. So, you know, physical evidence is the main thing that comes to mind when we're talking about preservation, but it's just as important to remember when you're talking about recorded statements from witnesses or insureds. You got to make sure that stuff is maintained in a good format so it can be tracked and the metadata essentially can be referenced to authenticate it at a later date when it comes up. So the issue of preservation applies to everything, even if it's created by you, the adjuster, or you, any investigator, not just the car or the product or other physical, tangible evidence.
An excellent point. Yeah, let's move on to the next slide here. So talking about how the determination of fault affects the subrogation claim. Let's start with Cam here and let you go first on this one.
Sure, thank you. So the issue, as I read this question, when somebody's referencing the determination of fault, I usually see that pop up either in a police crash report or in the notes from a claims adjuster about their determination as to who is liable in an accident. So when I'm getting a file, usually I'm getting them at the litigation stage and my case is in suit and I have some hearing coming up. And so when I read that issue of who's at fault based on either a police officer's opinion or a claims adjuster's opinion, it's really not much of a a factor for me to consider at that point. I mean, it's not evidence, and at the end of the day, it's not a determination made with evidence that I necessarily can admit in a case. So the way I treat a fault evaluation is it's at least a starting point for me to piece together how an accident may have occurred, and at least get kind of a 30,000-foot view of a case. But at the end of the day, it's not something that has a significant impact on a case, or any impact at all, I should say, once we get to the point of actually stepping into a courtroom to litigate this in front of a judge or a jury. Once it's at that stage, then it's entirely an issue of what evidence do I have and what evidence can I present during that process, that trial, to prove liability in a court of law, as opposed to determine fault based on the extrinsic evidence we might have available.
Any others want to chime in and have any thoughts on this question?
So I kind of thought of it as a little differently. I kind of think of this as, you know, if the claims handler usually determines fault toward the end of the investigation process internally, and, you know, there's some good and bad things that happen once a determination of fault is made. You know, I think on the good side of things, first of all, that may trigger subrogation, and by virtue of potentially having a subrogation claim, that triggers the work product privilege. So, you know, once a liability determination is made or potential subrogation evaluation is made, then arguably everything that the client is doing is protected, and we can at least argue confidentiality and privilege. I think that it helps the claims handler avoid waiving subrogation rights. So, you know, if there's a potentially at-fault party and you're always thinking in the back of your head, we need to subrogate, then when you're making a payment, you're always sort of mindful that we're not going to do something that's going to prejudice our right to pursue the at-fault party. Sort of some of the bad things that I've observed occasionally happen is once an at-fault determination is made, then that also kind of limits the focus of the subrogation claim toward the at-fault party. And frequently in litigation, we find out that there may be, you know, 2 or 3 potentially responsible parties, and we like to pursue everybody. So, you know, if there's a demand letter toward one party, you know, we'll frequently add parties to litigation claims, and we're pursuing other parties, and they're like, this is the first we've heard of it. You know, whenever you're involved in a product claim or a negligence claim for construction or maintenance, you know, you've got the owners, you've got the users, you've got the manufacturers, you've got the sellers, you've got the maintenance company. I mean, there are a lot of parties. So I don't know, it can be good and bad, but I agree completely with Cam. You know, once a file comes to me, you know, even if the client thinks, well, you know, we should be able to recover a little bit of money, I always go for 100%. I mean, so I start fresh and we go at it. You know, in Indiana, for example, they use a modified comparative fault system. So if we can't recover and put fault by more than 51% on an at-fault party, we can't recover. So if a file comes to me and it's already been determined that it's a 50-50 case, there's not much I can do with it, at least in Indiana. I mean, if we've got a auto accident, for example, and it's I had the green light, you had the red light, and the other party says exactly the same thing, and there are no witnesses, I can't recover, because I'm going to go to court and the judge is going to say, well, that's 50-50, and that doesn't mean we get 50% back. That means we lose, we get nothing. So, you know, it varies. Sorry to ramble.
Oh, no. Tiffany, you have anything to add to that?
Yeah, just a few things. So I agree completely with Cam and Michael that the ultimate determination of fault is the fact finder. So that's whether it's the judge or the jury. So that's who determines fault. Obviously, in the normal course of handling a claim, it's going to be the adjuster who's going to determine fault in order to properly adjust the claim. So I recognize that. But when the files come to me and there's a determination of fault, I separate them. So if the file is saying that the other person is more than 50% at fault, then that really is not conclusive. But if the claim comes to me and the client is telling me that their insured is more than 50% at fault, well, then I'm going to look at things a little bit closer. And the reason I say that is because that potentially can come up later in the litigation if the adjuster has to testify, especially if bodily injury benefits were paid out. So if your insured wasn't at fault, why did you pay out bodily injuries? So that's why I'm looking at when it's a determination that the insured is at fault, more than 50% at fault. But the good news about Michigan is that in the uninsured context, a owner of a vehicle, or registered of a vehicle, can actually be 100% at fault and you still can recover. It's assuming the vehicle is uninsured, they were involved in a motor vehicle accident, and the benefits that were paid out were PIP. So you have to have those three requirements. So PIP benefits, or personal protection injury benefits, it has to be that the person we're seeking those benefits from is actually uninsured, and they're the owner or registrant of the motor vehicle that was involved in the accident. Now, you notice I say involved in the accident, the actual person who we're seeking benefits from does not need to be involved, just their vehicle. So if they're the owner of the vehicle and somebody else was driving, that owner is still liable.
Excellent point to bring up, Tiffany, and highlights the fact that you work in Michigan, which is a no-fault state for motor vehicle liability cases or motor vehicle claims. So it's a little bit different than what I think the rest of us are. I know Mike does some work in Kentucky that has a sort of a hybrid system where they do have PIP, but they also have your traditional at-fault motor liability case. So just keep that in mind when Tiffany's talking about Michigan. It's a little bit different animal. You know, they do things a little bit different than state up north. I can't say too much because you guys have bragging rights right now on Ohio State, but let's go ahead and move on to the next slide, question number 4. And let's stick with Tiffany. And there's a question here about statute of limitations, which, you know, it's not always as cut and dried as our clients think, right? So, and Michigan's a little bit even more confusing, I think, when it comes to determining this. So I'll let Tiffany start off on this one.
Yes. So Michigan is confusing because it's highly litigated and highly legislated to get to the same confusing result. So that's where we are. The Michigan No Fault Act makes everything more complicated. So in a traditional uninsured action, because in Michigan we have, again, it's a no fault state. So that means there's immunity against a tortfeasor if they had insurance at the time of the motor vehicle accident. So if they are insured, they have immunity with the exception of what we call mini tort, which is a small deductible payment in that sense. And by the way, that statute of limitation is 3 years. For a traditional uninsured motorist action, the statute of limitations is 3 years. It's a negligent statute of limitations. However, I just referenced earlier, there's a situation where we can go after parties that are not at fault who had an uninsured vehicle that was involved in the accident and PIP benefits were paid out. That statute is 6 years. However, do not wait 6 years to refer the file. One, because we could potentially have an action for the negligence and for the PIP, which makes our case stronger. But two, you just don't want to really wait 6 years to file an action, especially considering the PIP. But the statute of limitation is 6 years for that. Now in Michigan, we have a priority statute regarding what insurance company will actually pay. And so there are different statute of limitations for that. So when I'm going after another insurance company for PIP benefits that were paid, if we're going after an insurance company that's on the same level, or we call it the same tier as the client, then that statute of limitations is 6 years. You get 6 years to bring that action. If I'm going to an insurance company for a recovery of all of the PIP benefits that were paid out, so going to a higher priority insurance company, that statute of limitations is 1 year. Now, there's some tolling of that statute of limitations that can apply. For example, if payments were made, if they were put on proper notice. But the statute of limitations is 1 year from the date of the accident. Now, there's a caveat to that. Sometimes an insurance company may pay the other insurance company, opposing insurance company, may pay PIP benefits, but then stop paying. So you're well beyond your 1 year statute of limitations. You still can bring that action as long as you have bills that were incurred within 1 year. And then that's called the 1 year back rule. And so sometimes people get that confused. The 1 year back rule applies to the ability to recover bills that were incurred 1 year back from the date the complaint was filed. So that's the 1 year back rule. The normal statute of limitations for just normal recovery against a higher priority insured is 1 year from the date of loss. So I know I've confused everybody.
That's okay. And there's also a 1 year statute of limitation in Michigan if the vehicle is parked, right? Is that correct?
Thank you, Ted. That is correct. So thank you. So in Michigan, you have a 1 year statute of limitations for a parked vehicle. The exception to that is if the vehicle is uninsured. Now, the tricky part about this is you should always refer the file within 1 year, regardless if you think it's uninsured or not. The reason being is sometimes it's not really uninsured. It's insured, but the insurance company has denied benefits. That's not an insured. Their denial may be correct or it may be incorrect. We have to litigate it. And we have to bring that action, no exceptions, against the actual other insurance company, directly against the other insurance company within 1 year. So once you get notice that there is potentially an insurance company, you should just assume that there is insurance, refer the file over as if it's insured, because that 1 year passes regardless of, if you thought that they had denied the claim, properly. That doesn't matter. It's just 1 year from the date of the loss.
Okay, so in summary, if you got a Michigan SOL question, do what I do, ask Tiffany. And it's always best, you can't go wrong with referring it as quick as possible in under 1 year. So Cam,
Absolutely.
can you let us know about the states you practice in, Pennsylvania and New Jersey?
Sure. So in Pennsylvania, it's for the most part a uniform statute of limitations of 2 years for both bodily injury and property damage claims arising out of negligence. And then in New Jersey, there's a split for bodily injury. It is a 2 year statute of limitations, again, from the date of loss, and it is 6 years for property damage claims. So similar to what Tiffany said, while I have a lot of time to get things going, I never wait 6 years to get a suit filed, and I really hope my clients aren't waiting 6 years to get the referrals over to me either. And in both states, there is a bit of an exception, not nearly as complicated as Michigan, but if you're handling just a property damage claim, for example, as opposed to a subrogation claim specifically, there is a immunity issues related to public entities. And in both states, that can actually shorten your timeline to get a claim filed first through an administrative process and then beginning the litigation process as short as a year. So as Tiffany said, I think we all agree, the sooner you get that over to your litigation attorney to get things going, the more likely it is your claim is protected and not going to be outside of the statute of limitations.
And Mike, can you tell us a little bit about Kentucky and Indiana?
Well, I thought Kentucky was the Wild West until I heard Tiffany talk about Michigan. So in Kentucky, product liability and personal injury actions have to be brought within 1 year. Just remember 1 year. And then if it's a car accident, it's 2 years. Now, of course, those statutes can be extended by PIP payments, but boy, if it's not a PIP payment, if it's just like a med pay payment, it doesn't count. It doesn't extend the statute. So just remember 1 year is really the deadline I would like everybody to remember in Kentucky. Now, of course, we can handle files very quickly. So I don't want to encourage everybody to give us files like at the, 51.5 week mark, but we are able to do that when we need to. In Indiana, it's 2 years. And then both states have a 5 year and a 6 year for damage to real property. And then it's also important to remember that there are statutes of repose, which cut off claims in construction and product claims. So in Indiana, it's 10 years. If the product was manufactured more than 10 years ago, you have no claim, no matter when it exploded. And in Kentucky, there's a presumption after, 7 or 8 years.
That's a good point. Yeah, Ohio also has a 10-year statute of repose. And then in Ohio, again, both bodily injury and property damage are 2 year statutes of limitation. There's a 4 year statute of limitation for damage to real property that I don't think a lot of people understand. And then some of the other oddball things. Technically, the statute of limitations for an intentional act is only 1 year in Ohio. I don't think most of our clients understand that, but also in my practical experience, if you have a road rage situation or situation where somebody intentionally struck another vehicle, I don't see too many people trying to raise a statute of limitations defense and say, no, I did it on purpose. So it's kind of a catch-22 there. And then also I see quite a few national tort or federal Tort Claims Act cases, which are a whole different animal. You generally have 2 years to make the administrative claim or file your SF-95 claim form with the particular department of the federal government. And then the statute runs 6 months after the liability determination that they make. So if they accept it, it's not an issue. If they reject your claim, then the statute of limitations on the Fed Tort Claim Act is going to run 6 months from the date of their denial letter. So that's just some of the different things that we see. Looks like we do have a couple of SOL questions in the chat for Michigan. Question for Tiffani. 2 Michigan insured vehicles involved in an auto accident out of state where there's no injuries. Which state law applies?
Well, it depends. That's a very lawyerly answer. So typically, it's going to most likely be the shorter of the 2 statute of limitations between the 2 states. So like, for example, I use Ohio because that's usually what I see most frequently, where accident occurred in Ohio, but you have 2 residents of the state of Michigan, then usually you're going to apply the statute of limitations in Ohio. Now, sometimes some courts will allow you to make the argument that although the accident happened in Ohio, you have 2 parties on either side of the V, for the lack of better terminology, that are Michigan residents. And so Michigan has a greater interest in adjudicating that matter. And so they will allow the typical Michigan no-fault act to apply. But sometimes that's at your detriment, because if they are both insured, then there's a bar on recovery. So it is going to depend, but most of the times it's going to be the shorter of the 2 statute of limitations.
And then one more Michigan question. SOL for Michigan mini tort to recover property damage from another carrier. Is it 1 year?
So that's a defense that insurance companies use. The policy provides that the mini tort claim has to be brought within 1 year. However, it's a negligence action. So a negligence action is a 3-year statute of limitations. Therefore, based on law, the statute of limitations is 3 years. However, a defense that's frequently made is that the policy provides that mini tort has to be brought within 1 year. Our position is whether the insurance company pays the mini tort or the actual tortfeasor pays the mini tort is still owed nonetheless. So with that being said, and go a step further, I should say, in Michigan, you can't bring up the fact that the person was insured. So you can't bring up information about insurance anyway, and that's probably consistent with other states as well. So it would be irrelevant that the policy would deny the mini tort claim and the actual insurance company didn't pay the mini tort, because that tortfeasor is still legally on the hook for 3 years.
Well, I think we've heard enough about Michigan statute of limitations for today anyway. Let's move on to the next question.
Wake them up after hearing about boring Michigan.
Mike, can you talk about what's a good settlement offer?
Well, so my starting position on every case is I want 100%. And I think we all feel that way. And I don't think it matters how the claim has been previously, discussed or debated and, fault has been assigned. I think once we get a file and we decide to go after it, we want 100%. So our starting point is always 100%. I try not to we try to enter into a dialogue early on, because I believe that any dialogue is good. But my position is I really want to maximize the recovery on every single file. So I'm not looking to go low early, but I do believe that opening a dialogue is generally a good thing. When fault or damages is an issue, and especially when you have an uninsured claim, the facts can vary so much that it's really difficult to say, lump all these together and say, this is a good offer, this is a bad offer. It's just impossible to do. It depends on the insured, it depends on the facts. I mean, there are so many variables that we really have to evaluate it on a case-by-case basis. Generally, I believe that on a good file where I believe that I can recover, I like to see an offer in the range of 75 to 80%, because from that point, I believe that there's a little bit of wiggle room up or down. And then at some point, when you start pushing into the 90%, 85, 90, 95% range on a case, then you get into a situation where you're looking at potentially diminishing returns. So for example, the risks of trial, which are completely unpredictable and crazy, and whether your witnesses show up and whether the judge is having a good day and whether your documents are there, and depending on what the jury's paying attention to, and the lost productivity of taking a couple days out of the office and making everything come together. Sure, you could potentially get 100%, but generally it's not worth it. So generally, if you can get up into the 75, 80, 85% range, I think that's a good deal. And at that point, we really need to consider whether to settle or not settle.
Great answer. Go ahead, Tiffany. I was going to try to move on quickly just because we're already at 11:40. So I want to wrap it up on this one if it's okay, and just add. It's the ultimate lawyer answer. It depends, but it depends on a lot of different variables, where you are in the case, what potential expenses are coming up, what's the cost benefit analysis. If you're at a junction in the case where you're going to have to pay some more money out for an expert and you have a settlement offer that's palatable, you might be in a better position to just accept at that point, or before you have to have inconvenience your client and then have the claims people appear as witnesses, and whether deposition expense. There's all kinds of different factors. Of course, now I'm rambling on it, but I think it's important to remember, though, we're trying to get the best for you, and particularly if we're handling on a contingency fee, which we usually are. We've got skin in the game. We've got no reason to shortchange our clients because we'd be shortchanging ourselves. So we try to, as much as possible, to explain that to the client. This is why I think you should accept or reject. And this is the reasoning. So let's move on to the next slide if we could, just to kind of try to make sure we cover all the ground. So the question was, what was a recoverable court cost? And I think for the lay people on the line, we probably need to make a distinction for court costs versus litigation expenses versus attorney fees, because those are all three different concepts. So let's start with Cam. Can you tackle this one?
Sure. So generally speaking, and I mean, this is another lawyer answer of it depends, but generally speaking, the costs that I can recover in Pennsylvania and New Jersey primarily just relate to the filing fees, the court costs. Other than that, costs that we tend to incur can be attorney's fees or costs for expert witnesses, deposition costs, fees for transcripts, things of that nature. And generally, even if you request compensation for those or have them added to your judgment as a taxable cost, most judges that I've been in front of will not grant a plaintiff those costs and as part of the judgment. And there's a number of reasons for that. I mean, in my states, there are statutory requirements that a plaintiff has to meet, and usually those requirements involve essentially outrageous conduct on the part of your adversary. And that becomes a scenario where most judges tend not to, want to penalize either attorneys or litigants that they see on a regular basis. But even more than that, a person has to do some pretty egregious conduct before a judge is going to agree that you should be entitled to those additional taxable costs for the litigation process. So the general answer is, outside of your court costs, don't plan on recovering much, if anything. But again, it's a case-by-case basis situation where if the situation arises where we feel the need to request those costs, we'll make that effort and go before a judge to argue it.
Yeah, so it's the same way in Ohio, which adopts what's called the American rule, which is generally people are responsible for their own litigation expenses and attorney's fees. But judgment or court costs or filing fees are typically awarded in judgments. Mike, does Indiana and Kentucky generally follow the American rule?
They do, basically the same.
Okay. And Tiffany, what about Michigan?
Same here, court costs and process service expenses.
Okay, very good. All right, let's move on to question 7. Are self-insurers entitled to subrogation recovery? Tiffany, if you want to take this one.
So yes, they are entitled to recovery. If obviously the other person is uninsured, and this is again in Michigan. So let's just talk about Michigan. I'm just talking about Michigan. So they are entitled to recovery against the other person that was involved in the accident if they were uninsured. Now let's say they were insured, then we're talking about mini tort. So there has been a lot of discussion and even some arbitration panels that have said that a self-insured entity is not entitled to mini tort. I've looked for case law. I have not seen case law to that effect. The argument is based on statute MCL 500.31015, which indicates that a self-insured entity is to be treated as an insurer. And if you're treated as an insurer, then an insurer is not entitled to mini tort. And so some courts observe that analysis, and therefore they will not award a self-insured entity mini tort. Some case courts will allow a self-insured entity to recover mini tort. So if we're talking about mini tort, it depends in Michigan. But if we're talking about the full amount of the damages, it's a complete recovery as if any other person that's out of pocket that damage or any other insurance company.
Anything to add to that, other panelists? I would just
So-
say generally, oh, go ahead.
No, I was going to say generally in Indiana and Kentucky, it's an equitable action and it is allowed as we're seeing self-insured retentions increase. We're seeing more self-insureds try to pursue recovery. It's a little bit more tricky, if you will. So we have some of the common defenses that have come up because we're not dealing with contractual obligations. We need to be careful that the defenses you might see more often would be the made whole doctrine. You might see a prohibition on claim splitting, and you might also see an argument that a voluntary payment doesn't give right to a subrogation claim. So what I like to recommend in that situation is to get an assignment upon payment so that you're crystal clear that you've got a contractual assignment of subrogation rights to pursue the at-fault party whenever there's a payment made. But yes, you can equitably subrogate in both states.
Yeah, and we handle a number of these claims where, you know, fleet vehicles get damaged and we're representing, although I guess it's technically not a subrogation claim because it doesn't involve insurance, but it's a damage claim nonetheless, right? So some of the issues I've seen that arise with that are, can we recover administrative fees for our handling of the claim? And I would say generally there's not really a lot of support in law for that. You know, you can demand it, but when push comes to shove, if it's resisted, I don't know that you're going to win that argument in court, and I wouldn't feel very strong about making that argument in court. Some of the other ways where it gets a little trickier with a self-insured entity is when you're talking about loss of use claims. We had this truck was down for 7 days. If push comes to shove and you had other vehicles available, was there really a loss? So it can be a little bit trickier proving your damages in those types of claims. But as a general matter, yes, you are entitled to recover your damages nonetheless, you know, whether you had insurance or not. So let's move on to the next question. How do you recover court order restitution payments? So I'm gonna be a little selfish and ball hog here because I've got a little, I've dealt with this enough over the years that I have a little spiel that I give to all my clients. So, and I will address it this way. So in Ohio, typically, insurance companies are not eligible to receive restitution payments. Your insured may be entitled to receive them, and that's a dangerous game to play. So I always recommend that our clients, if they have a loss, regardless of whether there's restitution payments being made, that they place the file with an attorney to get a civil judgment. The reason I say that is because you can do lots of things, and we'll talk about that a little bit later here. You can do lots of things to enforce your civil judgment and ways to recover monies and post-judgment remedies, but you really don't have standing to, at least in Ohio, to force restitution payments to be made to a carrier. They're typically being made to your insured. Now, you might have reimbursement rights via your policy against your insured, but do you really want to go down that road if you have to? But I'll let anybody else jump in for how restitution's handled in their states.
Sure. So in the two states I practice in, both in New Jersey and Pennsylvania, an insurer is permitted to recover restitution through the criminal process. In New Jersey, the statute's written somewhat vaguely, but the New Jersey Supreme Court decided in the 90s that it does not specifically exclude an insurer from the word victim. So you are entitled to recovery there. And in Pennsylvania, the statute specifically provides for insurers to recover as restitution payments if they have compensated the victim for the loss prior to the ordering of the restitution payments. Now, despite the fact that you can recover, I agree with Ted in that I would still advise my clients to pursue their own civil claims separate from the restitution order. You can't collect on it twice, obviously. You can only collect the same amount of money once, but I've run into issues trying to monitor collection of restitution payments where, whether it's a prosecutor's office or district attorney's office here in Pennsylvania, they're focused on a completely different proceeding than what your focus is or what my focus is as the subrogation attorney. And I've unfortunately seen mistakes pop up where numbers get mixed up, paperwork gets mixed up, and you've gone through your process of proving a restitution amount being owed. You've attended a hearing, you've submitted your documentation for damage. As that person's making payments over the course of a few years, maybe an invoice accidentally gets put into file and your restitution amount gets modified or reduced for some reason. And then this person's sentence is completed, their probation is done, and you really have no enforcement mechanism for this balance that has suddenly been mistakenly adjusted, which, believe it or not, I've seen multiple times. So it is always worthwhile to have your own civil case. And it also gives you separate collection activity options should the restitution payments not be made for any reason.
Anything to add to that?
Yeah, I'll just quickly, just for the purpose of Michigan, that Michigan, an insurance company can recover restitution payments as well. But in practice, what actually happens is the insured is usually the person that's contacted, and so the insured is usually the one who's dealing with the prosecutor. And so when the judge makes that award, it's usually to the insured, although they may or may not have been the proper one to be entitled to that actual award. So if the judge knows about the insurance company, then yes, I have seen payments go directly to the insurance company, and there's no prohibition on that. But usually they go to the insured because that's who the parties know about, and they don't know about the insurance company. So I agree, as Ted and Cam said, file your civil action.
So in Indiana, an insurance company can recover restitution, but in Kentucky, they can't because they're not the victim. So, and I've seen that frequently in Indiana where, you know, we're sitting back waiting to collect the payments from a restitution order, and all of a sudden the judge decides, yeah, he's good or she's good, case is over. And then you've got nothing to do. So you really do have to convert a restitution order into a civil judgment if you want to enforce it.
That transitions into the next topic in the next slide very well. So what collection activities are available against an uninsured person? So typically, you know, we do a lot of collection where there's an insurance company on the other side. We try to settle those, but in the situations, particularly we're doing an uninsured driver, we may take a judgment. What sort of post-judgment remedies are available? Start with you, Mike.
So, you know, I just wanted to make a comment that at least in Indiana and Kentucky, the fact of not having insurance and driving around within those states where they require insurance doesn't automatically make somebody at fault for a liability accident. So it's not, you know, negligence per se to drive around and cause an accident and just not have insurance. But typically what we do is if there's an unpaid judgment, we can suspend a driver's license. And that's really the number one thing that motivates people to find some money and pay the judgment. And then we frequently will do judgment debtor examinations where we'll ask questions about assets and income to try to satisfy the judgment, which is really great because, often we can get together and, when you're face to face with somebody, you can sort of convince them that they need to start making some payments. But we can also garnish employers, and we can garnish wages, and we can attach bank accounts. There are also all sorts of clever execution remedies available that most clients don't want to pursue because they do have some risk of potential liability if you do the wrong thing or grab the wrong item. But that's primarily what we do to collect judgments.
What about in PA and New Jersey?
Well, virtually an identical process over here as well. Both states have a statute that says if a judgment debtor fails to satisfy the judgment within 60 days from the date it's entered, that a license suspension can be imposed. Obviously, this relates only to motor vehicle accidents, not every judgment debtor. But in addition to the license suspension route, we do the same thing. We do wage garnishments, we do bank attachments. It can be a little more difficult to achieve those processes in a subrogation matter because the information to pursue them is not readily available like it would be for a consumer collection case, for example. But our collection team, I've noticed, especially in my files since I've been here, they're doing a very good job and very diligent in finding that information and pursuing it because sometimes a license suspension isn't available. I mean, sometimes police officers don't write that license number on the police report, or it can't be located. Or a lot of times people driving around with an uninsured vehicle don't have a driver's license to begin with. So there can be all sorts of other issues that pop up when you're working through the flow chart of collection activity post-judgment, but luckily we have a lot of resources to tackle all of them.
Tiffany, what about Michigan?
Michigan the same. The addition is that we can do a tax garnishment on the state taxes in Michigan. It's been referenced that we can also do a judgment lien, so we can do a judgment lien in Michigan. We can definitely suspend a driver's license and do attachments to wages and bank garnishment. And it's been alluded to, although we don't really do it, but if a client feels it's appropriate, we can obviously seize vehicles, but that's something that has to be approved by the client if you're interested.
I think airplane just landed outside your window, Tiffany, but
That's mine. I thought it was mine.
Same thing in Ohio: judgment suspension, wage garnishment, bank attachment, and other post-judgment file a judgment lien, as well as other remedies. So let's move on to question 10 here.
Oh, I'm sorry, Ted. Real quick, I just want to interject. And the judgment in Michigan lasts for 10 years, and you can renew it after 10 years. I'm sorry, I forgot to say that. Just wanted to let clients know.
Yeah. Okay. And then question 10, just kind of checking in, how are your courts? The world changed sort of in the pandemic. I can tell you in Ohio, which is not a unified court system, it really varies by court to court or judge to judge. But in general, I will say that there's a lot more scheduling hearings and whatnot that are virtual as opposed to in person. However, I said a majority of them for an evidence hearing or a trial will require in-person attendance. Let's go, Cam, what's PA, New Jersey doing with that?
Very similar. So Pennsylvania is also not a uniform system, and right now it's mostly up to county by county or judge by judge, even within counties. But similar to what you stated, I mean, pretrial conferences or settlement conferences, a lot of times those can be conducted virtually, or at the very least, I know I might have to appear in person, but I rarely have to have a client or a representative of an insurer available in person at those settlement conferences. They're always allowed to participate either via Zoom or just be available by phone. New Jersey is a uniform system, but for whatever reason is essentially doing the same thing Pennsylvania is right now, right? It's really a judge by judge basis, and really the type of proceeding you're dealing with, whether it's going to be virtual or in person. But for the most part, trials and evidentiary hearings across both states, they have been converted back to in-person hearings for the majority of the year. So.
Tiffany, what about Michigan? What are you folks doing?
The exact same thing. So, it depends on the proceeding, usually trials or any type of hearing where the judge has to assess credibility is going to be in person. Other than that, most courts, with the exception of, the UP, most courts will allow you to appear via Zoom, especially a run-of-the-mill settlement conference or a pretrial hearing.
Mike, do you speak to Kentucky, Indiana?
Kentucky and Indiana are exactly the same. So, the courts are now open, and a lot of courts in the local jurisdictions do expect you to show up. They do often provide a Zoom or remote attendance ability, when you're talking about ministerial or administrative tasks, but for evidentiary hearings and trials, you got to show up in court.
Very good. So we actually got through the 10 questions, and we might have to rush a little bit at the end there. So I apologize for that. But if anybody should have any other questions that you want answered, our contact information is right there on the screen. Never hesitate to reach out to any one of us. We will get you the answer, and we're happy to work with you. I hope you found today's session to be informative. Thank you for attending. So just as a reminder, you will get a short survey that will pop up on your screen when the webinar ends. Please share your feedback with us because that helps us determine future webinar topics. I'd also share that we do have a library of 40 past webinars that the firm has done. And we will send you a link to that library in our follow-up email. So thank you again for attending, and have a great rest of your day.
Thank you.